Yep. You guys are reading that right. Yep. Judge admits nearly being persuaded by AI hallucinations in court filing. Plaintiff's use of AI affirmatively misled me. Judge Wright. A plaintiff's law firms were sanctioned. This is the good news. The judge sanctioned and ordered them to pay $31,100 after submitting fake AI citations that nearly ended up in a court ruling. This is the good news. Michael Wilner, a retired U.S. magistrate judge serving as special master in U.S. District Court for the Central District of California, admitted that he initially thought the citations were real and almost put them into an order. Now, if you don't know what a special master is, a special master is a particular type of lawyer who has imbued legal powers that are typically reserved for other lawyers that are part of a kind of like a systemic imbuement of the same power. You might have seen this on some TV shows or movies, but you can look up the definition for yourself. It's usually done in circumstances where, as an example, you have a lawyer who, let's say, gets 404'd as part of an ongoing investigation into a client they had, which was under investigation by police because of another 404. So then what happens is, well, how do the police appropriately look at the legal information that the lawyer had about the 404'd victim, who then the lawyer also became 404'd, right? You have to respect the privacy of not only the initial victim, but also the lawyer who was originally involved with the victim, and they so happen to also be 404'd. So then you have a special master step in, and the special master can kind of replace, in very extenuating circumstances, by having the same, let's say, essentially legal rights as the original lawyer, for example. And that way everything can continue as is necessary legally to continue. Okay, so that's what a special master does. So the reason why this is of particular note is because a special master has the potential to have more legal rights in some cases as a lawyer than a typical lawyer might have. It's very extenuating, but it can happen. And to have a special master almost be compelled by AI hallucinated legal arguments is absolutely mind-boggling. These aren't the first lawyers caught submitting briefs with fake citations generated by AI. In some cases, opposing attorneys figure out what happened and notify the judge. In this instance, the judge noticed that some citations were unverifiable, but was troubled by how close he came to including the bogus citations in an order. Directly put, plaintiff's use of AI affirmatively misled me, Judge Wilner wrote in a May 5th order. I read the brief, was persuaded or at least intrigued by the authorities that they cited, and looked up the decisions to learn more about them, only to find that they didn't exist. That's scary. It almost led to the scarier outcome from my perspective of including those bogus materials in a judicial order. Strong deterrence is needed to make sure that attorneys don't succumb to this easy shortcut. Can anybody tell me why? Okay, hang on. Can anyone tell me why Judge Wilner here, from his perspective, thinks that the scarier outcome would have been including the bogus materials in a judicial order? If they're included in a judgment, it sets precedence. So the logic is really simple. The reason why judges include court cases, this is why you have what are called, wow, I completely forgot the name. They're secretaries. They're legal secretaries, I think. I think that's actually the name, the legal secretaries. As a legal secretary, one of your jobs is to, I have a little bit of historical background in legal stuff. Not any formal education, just I've been around it. So I kind of understand bits and pieces. A legal secretary, a paralegal, thank you. Geez, that's it. Paralegal, not legal secretary, paralegal. Thank you, Chief. What they'll do is a lawyer will go to them and say, look, I need you to go look at court cases which have these factors and these outcomes. And I'm going to use these court cases for my current case so that I can persuade the judge that they don't have to do any further research into the context or aspects of this case. What all they have to do is accept the fact that a previous judge has already ruled on such conditions in this or that way. And though that precedence means that the judge I'm currently trying to persuade can count on the fact that other judges have also come to the same outcome. So that's what a paralegal will normally do. They will go and hound, whatever legal libraries there are, and they'll get their hands on cases and they'll figure it out. As an initial starting point, it's included in this article. As an initial starting point, the lawyers included precedent-based, what do they call them? Citations, in order to try and persuade the judge to come to a certain outcome. If this judge had not confirmed that those things existed and then had put it as a matter of record, what do you think that means? That means that the next paralegal who goes and looks up the actual conclusion of this court case is going to assume that all the citations of this court case are also based on precedent. And so it creates a scenario where if you're not checking for whether or not these citations exist, it actually becomes easier and easier for them to escape scrutiny. This was good because it's a first line of defense. Simply eliminate the citation in the first place, and then it never gets to that point. But it's scarier if it got past this point because it falls under less scrutiny. It's far less likely for it to be found out as false citation. It would just be assumed that because it's a matter of record, then all due diligence was done. The outcome has been supplied. Let's just go with it. But even still, let's imagine for a moment that it passed. It passed this, okay? And then several other, because you have to think about it as kind of like a web, right? So one outcome one judicial outcome leads to a web of other outcomes based on the precedence of this outcome. So then what happens is it expands. You have a what do you call it? A magnitude of order expansion as things progress. At some point, yes, you might figure out maybe that this citation was based on a bad foundation. But now what does that do? Now you have to go back through all other outcomes, all other judicial outcomes that were based on the origin source of the bogus claim, and undo all of them. That's how it works, because those outcomes are now based on bad information, which means you have to go through a retrial, or sometimes you don't even get that opportunity. It might be an appeal. It doesn't matter. Essentially, you just have to undo the entire judicial process because they were all based on bad foundations. So the precedent might go away, but the consequences are more and more and more severe the farther down the supply chain you go, which is a great analogy. It's an allegory in real life to what we do in the tech industry. That's exactly what's happening and has been happening for the last 10 years. So this is why I wanted to bring this one up in particular. It turned out that the AI hallucinations weren't too far off their mark in the recitations of the substantive law, but that doesn't excuse the lawyer's use of AI in Milner's view. That's a pretty weak no harm, no foul defense of the conduct. This judge is based. The sanctioned lawyers are representing former Los Angeles County District Attorney Jackie Lacey, who sued State Farm. Lacey's lawsuit alleges the insurance company refused to provide legal defense to her late husband, who faced a civil suit after pointing a boom boom stick at a group of activists who were on their porch. Bros, I'm not done. This gets worse. Large team of attorneys didn't notice fake cases. You bet your life it's happened multiple times. Lacey is represented by what Wilner described as a large team of attorneys. So the judge himself described it as a large team of attorneys at the giant K&L Gates and a smaller firm, Ellis George LLP. Wilner described the incident as a collective debacle. The attorneys representing plaintiff in this civil action submitted briefs to the special master that contained bogus AI-generated research, Wilner wrote. After additional proceedings and considerable thought, I conclude that an award combining litigation sanctions against plaintiff and financial payments from the lawyers and law firms is appropriate to address this misconduct. Wilner was appointed as a special master to oversee a dispute regarding State Farm's assertion of various privileges in discovery. Wilner found that a plaintiff's supplemental brief contained numerous false, inaccurate, and misleading legal citations and quotations. Approximately 9 of the 27 legal citations in the 10-page brief were incorrect in some way. That's a third. At least 2 of the authorities cited do not exist at all. Additionally, several quotations attributed to the cited judicial opinions were phony and did not accurately represent those materials. Second attempt at brief still had fake citations. The lawyers admit that Mr. Copeland, an attorney at Ellis George, used various AI tools to generate an outline for the supplemental brief. That document contained the problematic legal research Wilner wrote. Mr. Copeland sent the outline to lawyers at K&L Gates. They incorporated the material into the brief. No attorney or staff member at either firm apparently site-checked or otherwise reviewed that research before filing the brief with the special master. Based on the sworn statements of all involved, which I have no reason to doubt, the attorneys at K&L Gates didn't know that Mr. Copeland used AI to prepare the outline, nor did they ask him. During Wilner's initial review of the brief, he was unable to confirm the accuracy of 2 citations. He emailed the lawyers, asked them to resubmit the brief without the 2 correct citations, but with the remaining AI-generated problems in the body of the text. So they resubmitted, they removed the 2 that the judge found, but they kept the rest. They didn't even think to be like, well, maybe if the judge found these 2, maybe we should be checking what the hell else we included. So because the judge wasn't satisfied with their attempts to actually fix the problem, then he had to make them pay a fine. And then he states, don't use AI in the legal process. No duh. So, holy crap. Imagine that your life is on the line and your lawyers are doing this, or the judge is doing this, or they're all doing this and none of it gets caught. This is absolutely mind-boggling that this happened in the first place. But this is the real-world consequence of using AI without thinking. And the principle of this matter holds true in the tech sector as well. That's why I do what I do here. Because you guys need to see what the consequences are of not using your brain when you're putting these things together, and what the consequences are when we are too silent about these problems. I realize that a lot of you actually care about these problems, but there's very little you can do. Hopefully, the information I'm presenting helps you to understand and form and present logical, fact-based arguments to your colleagues, managers, executives, whoever it is you're talking to, that these things have real-world consequences. And it can cause a lot of harm.